Good morning, good afternoon, or good evening to everyone joining us. You have joined a South Center webinar, and we will be discussing the Ministerial Conference number 12 decision on the Agreement on Trade-Related Aspects of Intellectual Property Rights, which was finalized on the 17th of June of this year, 2022. So this webinar is being recorded, and we will have 3 presentations. I hope that you all have seen the program for today. I will be sharing just very quickly on the screen so you can see again our program, and I'd just go right ahead and introduce our first speaker, our Executive Director of the South Center, Professor Carlos Correa. Professor Correa, you have the floor.
Thank you very much, Viviana. So let me welcome on behalf of the South Center all the participants to this webinar. This is about what the next steps after the adoption of the decision by the Ministerial Conference in relation to the TRIPS agreement. So let me just make a few introductory comments about the decision. I will not call it the TRIPS waiver, because as you know, India or South Africa, sponsored by a large number of countries, requested something else. They requested strawberries, they were given potatoes. Both are nutritive, but these are very different species. So as we know, the decision is limited to vaccines 19. The request was to cover all kind of products, including therapeutics and diagnostics. The decision is limited to patents, while the request was to cover all intellectual property rights that may become a barrier to manufacturing vaccines and other products. So it's a very different outcome as compared to what was actually requested. So in any case, this outcome does provide some elements, and therefore the next steps should be, in our view, first, to make an interpretation of the decision and to look for the flexibilities. You are familiar with the concept of flexibilities for the TRIPS agreement. I think we also need to look at what this decision actually allows for and what is not permitted. I will mention a couple of examples in which this issue may be relevant. And secondly, there will be a need to consider other steps that member countries may adopt, given the limits of the current decision. These may include, of course, the use of the compulsory license system without considering the decision, as provided for in the national laws in accordance with Article 31 of the TRIPS agreement. Perhaps there may be a limitation in terms of exports, but this might be the only significant limitation, depending on how these provisions have been implemented at the national level. A second option is Article 73 of the TRIPS agreement, which provides for an exception in case of national security reasons. There is a paper that was published by the South Center, authored by Professor Abbott. Maybe Nirmalya or Vitor, if you can make available the link to this paper by Professor Abbott, in which there is an explanation how this article may be applied by any member in cases where there is an emergency, in this case, a health emergency. And a third step that members may adopt, I will elaborate in a minute about this, is in connection with interpretation of exhaustion of rights and parallel imports. But let me just make a few comments on the decision itself. First, I will note that the preamble is very short. There are two paragraphs. There is no elaboration in the preamble, and this may reflect the divergences among members in connection with the purpose and the scope of this proposed decision. But the relevant paragraph here indicates that this is applicable in exceptional circumstances of COVID-19 pandemic. So is making reference to the exceptional circumstances in the first place and making it clear that it applies to the COVID-19 pandemic only. It is also interesting to note that although, as we know, this decision refers to compulsory licensing, it does not mention this expression. As it is the case for the TRIPS agreement, that does refer to the use without authorization. In this decision, there is no reference to compulsory licensing. Again, the wording of Article 31 TRIPS is used, unlike the case of the Doha Declaration on the TRIPS agreement on public health, where there is a specific reference to compulsory license. In paragraph 3, it is explained what is the object of this decision. And then it is interesting to know that it refers to clarifications in plural and to waiver in singular. And this is actually confirmed in paragraph 9, in which there is a reference only to paragraph 3b. And this is actually the only waiver that this decision contains. The fact that a company which is granted a compulsory license or authorization without the consent of the right owner may export any quantities of the products which are produced. So clearly, this decision is more about clarifications rather than waiver, and the waiver which is granted, as you can see in particular in the footnotes, is subject to some conditionalities, which do not apply generally to a compulsory license, which are provided on the basis of Article 31 of the TRIPS agreement. So regarding the process of negotiations, the process was dominated by informal and small meetings in which most sponsors of this initiative could not participate. As we know, the final text was reached after a lot of discussions, in particular on footnotes. So quite interestingly, footnotes took a long time, hours of discussions about a few words in footnotes. For instance, in footnote 2, in relation to whether products, ingredients were mentioned. And as you may also know, the decision was submitted without sufficient time for members to consider it, and without actually complying with the rules in WTO that have requested a few hours to make a consideration. In any case, this is the outcome of the conference. And then, as I mentioned, the next step is interpretation. There are some ambiguities, and there are some areas in which it will be important to look how big is the policy space which has been retained. One example relates to footnote 2, which addresses the issue of the subject matter of the patents which are subject to this potential waiver. As you may know, the negotiation of this footnote took hours, literally. A lot of discussions about different wording that could be used. But then it's important that in footnote 2, there is a reference to includes ingredients and processes necessary for the manufacture of COVID-19 vaccine. So includes means that not only the ingredients and the processes may be the subject matter of patents that are waived, the use of which is waived. So it may include any subject matter which is required for the production and supply of COVID-19, as it is indicated in paragraph 1. So although this note was a subject, as I mentioned, of so much discussion, now it is very clear that any product which is required for the production and supply of COVID-19 may be subject to this decision. Possibly the intent of some of the members that participated actively in the negotiation was to limit the scope in terms of subject matter, but the text, as agreed, does allow for this broad interpretation. And this is one of the areas in which it will be important to look at what may be called the flexibilities in this decision. The second issue that I would like to address is whether there will be a need to grant a compulsory license in the importing country. So let's assume that patents have been granted in the country where this decision is applied, where manufacturing of vaccine takes place. So patents will be waived in relation to ingredients, the products as such, whatever the subject matter is. But the question is, when these vaccines are exported to another country, if in that country patents are enforced that protect the ingredients or protect the vaccine as such, would it be necessary to get a compulsory license? Would it be an infringement to import the importation of those vaccines? If we apply rigorously patent law, which grants an exclusive right to sell, then this would mean that this may be an infringement. So the only way of avoiding this issue and the granting of a compulsory license is through the consideration of parallel importation. Parallel importation is based on the concept of exhaustion of rights, meaning that once a product has been put on the market by the exporting party, the rights over these products are exhausted, and therefore no further measure can be taken in the importing country. But it's important to know that in many laws following the European approach, parallel importation is limited to situations in which the product was put on the market in the exporting country by the right owner or his licensor. So this means that these laws may be read in many circumstances as not encompassing parallel importation when the product was manufactured by a compulsory licensee, because in this case there is no authorization. It was not done with the consent of the right owner. So this will mean that it will be important as a next step in order to see the extent to which this decision may be applied, in particular for importing countries, and also to look for the potential markets for manufacturers that may eventually use this decision, if this is the case. Then to look at how parallel imports have been regulated and the extent to which parallel imports which are produced by a compulsory licensee are covered by this concept. In our view, this is the case. In our concept, although in the European context, the exhaustion of rights is limited to situations in which there is consent by the right holder, this is not a rule under the TRIPS agreement, and there is no reason whatsoever that would justify that this approach would be followed. We know Article 6 of the TRIPS agreement is very broad and allows countries to apply the doctrine of exhaustion of rights in any manner, including a broad manner. And therefore, products which are made by a compulsory licensee should be deemed to be permissible for importation under the concept of parallel importation and exhaustion of rights. So there are other aspects that Nirmalya and Viviana, my colleagues, will address. So thank you very much for the opportunity to make these comments. And of course, I remain available for any further question or comment. Thank you, Viviana.
Thank you, Professor Correa. Just to mention to all participants that if you'd like to pose questions, you can write them in the Q&A section below your screens. The chat is open, but please put questions in particular Q&A so that we'll be able to then follow them. We're going to continue with the presentations, and then afterwards, then we'll address the specific questions. So please keep those on as we continue. I give the floor now to Nirmalya Syam, our Senior Program Officer, to continue looking at the aspects on implementation of the decision. Nirmalya, you have the floor.
Thank you, Viviana. If you could just give me a minute, I'll try to share the screen. Okay. So I believe you can see the screen. So I will be going through some of the implementation options in relation to the provisions in the MC12 outcome decision. So I will first focus on paragraph 3A of the decision text, which says that an eligible member need not require the proposed user of the subject matter of a patent to make efforts to obtain an authorization from the right holder in terms of Article 31B. Now, generally, national patent laws dispense with this requirement to make efforts to obtain a voluntary license from the patentee, currently under their national laws, in situations of national emergency or circumstances of extreme urgency. Now, this pandemic being such a circumstance, obviously, those provisions of the national law would be applicable, and therefore, as was also mentioned by Professor Correa, this is not really a waiver, this particular provision. This is just a clarification of what currently national laws can, and certainly they do have such provisions, making use of the flexibility available in this regard under the TRIPS agreement. Professor Correa, I think, wants to make an intervention.
No, I'm sorry. No, not at all.
No, okay.
Go ahead.
Thank you. The next provision is paragraph 3B, which is the only limited waiver that this decision provides, and that too in a limited sense to certain aspects of Article 31F of the TRIPS agreement. It states that an eligible member may waive the requirement of Article 35F that the authorized use be predominantly used to supply the domestic market, and may allow any proportion of the product manufactured under this authorization to be exported to eligible members. First point to note is that this waiver in itself will not be self-executing. Many countries have in their national patent laws conditioned the grant of compulsory licenses to the predominant purpose of supplying the domestic market, in accordance with the requirement that you have in Article 31F. While some countries do in the national patent laws allow exportation, subject to this requirement being complied with, which means that India being an example, for instance, the Indian patent law allows the non-predominant proportion of the product manufactured under the compulsory license to be exported. WTO members having such provisions in domestic law, which restrict it to the predominant use purpose, for example, and want to make use of this limited waiver of paragraph 3B, would certainly have to make amendments to their legal provisions in that regard. Now, the waiver could be implemented also through subordinate legislation or executive orders, as has been clarified in terms of, I think, paragraph 2. Subject, obviously, this would be subject to provisions of the principal legislation. So any subordinate legislation cannot be ultra vires the principal legislation in the country. As Professor Correa has also mentioned, if there are patents in the importing country, unless the exhaustion doctrine applies, there would be a need for grant of another CL in that country. Now let's turn to footnote 1, which is about eligible members. Footnote 1 states that all developing country members, and this was the last provision in the decision, essentially, to be agreed upon in the informal consultations before it was adopted in the late or early hours of the ministerial on the final morning. All developing country members, the footnote states, are eligible members, but members that have existing manufacturing capacity, which means essentially those which can make use of a compulsory license under this decision, for example, and export, are encouraged to make a binding commitment not to use the decision. It is an exhortation. It is not a binding obligation currently, as it is worded, but it goes on to state that such binding commitments include statements made to the General Council. And further, it says that the TRIPS Council will record, compile, and publish such statements. Now, in international law, we must recall that state representatives who make legal commitments are not generally deemed to exercise full powers. And therefore, whatever they agree upon are subject to parliamentary or congressional ratification. That is the normal route of treaty making. But footnote 1 applies an implied consent approach to statements that may be made by delegates, including to statements that have been made in the past, as has been explicitly mentioned in footnote 1. Another point to note is that it is not clear what the form or forum for such binding commitments will be. Footnote 1 says that it will include statements made to the General Council, but that does not exhaust other forms of statements made in other bodies. And it is also not clear whether it is limited to bodies within the WTO or, for example, statements made in forums outside of the WTO. For example, if a state makes a statement to, that it intends not to use the system, say in WIPO or in the G20, for example, would such statements be compiled by the TRIPS Council, taken note of, and published as binding legal commitments? That is certainly not clear. So in view of this open-ended nature of the commitments that could be made under footnote 1, it would be pertinent for developing countries, delegations, to include a standard disclaimer in their statements in relation to the TRIPS decision, that nothing in the statement should be construed as a legal commitment under this decision in their statement, so that those are not then used against them later on to say that they have made commitments not to make use of this decision. Next, let's turn to paragraph 3C on export restrictions. Paragraph 3C states that eligible members shall undertake all reasonable efforts to prevent the re-exportation of the products manufactured under the authorization in accordance with this decision that have been imported into their territories under this decision. Footnote 3 adds an explanation that in exceptional circumstances, an eligible member may re-export to another member for humanitarian or not-for-profit purposes. Now, what those exceptional circumstances are is not defined. So member states have the discretion to define what the exceptional circumstances would be and allow for re-exportation per se in such exceptional circumstances for humanitarian or not-for-profit purposes. Secondly, this limitation would seem to only apply to products that are manufactured and exported under a compulsory license that is within the scope of this decision. It would not prevent, for instance, the exportation of a product that is developed further by using an imported product manufactured under this decision. For example, if country A grants a compulsory license under this decision relating to an ingredient, which is then exported to country B, and country B then uses that ingredient to manufacture a vaccine and exports that vaccine further, then that would not be coming within the restriction of paragraph 3C anyhow, regardless of footnote 3. Then the other point to note is paragraph 3C will not limit the application of the doctrine of exhaustion of patent rights such that when the product is manufactured or imported legitimately, the patent right is deemed to be exhausted and the product could be imported from the third country. As Professor Correa mentioned, national laws in some countries tend to limit or restrict the scope of parallel importation to products that have been put in the market with the consent or the authorization of the patentee, which need not be the case. And if the patent law allows for recognition of products put into the market under a CL as legitimately put in the market, which could be parallelly imported, such parallel importation would not be restricted by the prohibition, let's say, in paragraph 3C. This is further clarified by the fact that paragraph 9 says that nothing in this decision shall prejudice the use of other TRIPS flexibilities available under the TRIPS agreement as confirmed by the Doha Declaration. And the only exception, if it, as it were, is made in relation to paragraph 3B. 3C is not excluded, is not part of the exclusion from paragraph 9. And hence, 3C cannot be interpreted in a manner where it undercuts the use of other flexibilities under the TRIPS agreement. This is the point that I was just making here. Finally, just to recap some of the other possible measures that could be taken, which would be use of a compulsory license under Article 31F outside the scope of this decision. So using that to export the non-predominant part of the production. Export based on the grant of a compulsory license to remedy anti-competitive practices, which does not attract the limitation of Article 31F as already enshrined in the TRIPS agreement. An application of exceptions to patent rights by interpreting Article 30 of TRIPS consistent with rules of customary interpretation under international law to allow for manufacture and export of such products. And finally, as Professor Correa also mentioned, the use of security exceptions. I would stop with that. Over to you, Viviana, and we'll be happy to take questions and engage in discussions with you. Thank you.
Thank you, Nirmalya. If you could just stop sharing your screen, thanks. So we'll stop here for the moment, as this is the segment of our webinar when we were addressing the particular decision that, as you know, covers vaccines for COVID-19 exclusively. So we have had some specific questions in this context. Just to remind everyone, please, we would prefer if you put your questions in the Q&A, because we may miss the questions that are coming up in the chat as those come along. So it'll be more helpful for us to pick them up in the Q&A. So if you can please copy them there. But I will take two of the questions for now, as we continue to make sure we have enough time for a full session. So the first one of them, well, is with regards to the scope of what is covered under the decision. And there is the question about the fact that trade secrets is not under the scope. There is a reference to Article 39.2, but nothing that would be any waiver of what is required as a TRIPS obligation. So the question to Professor Correa is whether how do you view this played out in terms of implementation? The fact that trade secrets are very important for vaccines, and why perhaps was this not addressed in the decision? And in this context, what may be done about compulsory licensing for trade secrets? And we can mention we have had some exploratory ideas on that in some South Center publications we can note in the chat. Professor Correa, to you.
Well, thanks for this question. Of course, as we know, developed countries opposed strongly to the extension of this decision beyond patents. They were prepared only to talk about patents. They were afraid that there would be obligations on the companies to share the know-how, as it is indicated in the question itself. Know-how is very important. In some cases, is the key information in order to produce a vaccine. So clearly, this was in support of the Western pharmaceutical companies that denied any transfer of technology. They didn't want to share the technologies, in particular know-how, with potential manufacturers in developing countries. This is the fact. However, I will mention that these obstacles may be sometimes exaggerated. If there are firms in a developing country, for instance, which are familiar with the production of biologicals or maybe other vaccines, the know-how can be developed. So it may take longer as compared to a situation in which the know-how is transferred. But I would caution against against making this argument as strong as suggesting that without that, developing countries cannot move forward and produce vaccines. They can. It will take longer, as has been shown in some cases. Just also to mention that there is a publication, maybe Victor, you can also add the link to this publication by Professor Olga Gurgula, where she's suggesting the possibility of providing for compulsory license in relation to know-how or trade secrets. So that would be an innovation in most laws, but it's worth looking at this. In fact, in the United States, when the patent was subject to compulsory license, often there was an obligation also on the patent owner to transfer the know-how. So there are precedents for this, and this paper may help also to think about possible changes at the national level.
Thank you, Professor Correa. This brings us to a related question about what might be the potential impact or the need for use of the decision with regards to the patent landscape in mRNA technology and how this may affect the mRNA hubs. So as we know, there is a substantial number of patents on mRNA technology and the developments of the mRNA hub in South Africa, and then the collaboration with other regions through this. So if you have any comment on how you see that playing out. Or
well, of
Nirmalya.
course, yeah, or maybe Nirmalya can also address this. Well, certainly in the case of messenger RNA technologies, although this technology was developed more than 20 years ago, there are many patents. In particular, Moderna has got more than 200 patents in relation to this technology. Moderna pledged at one time that they will not enforce their patents in order to allow for the production of vaccines based on this technology, but it's unclear for how long this pledge will stay. So there may be obstacles, and also it's important that eventually patents may not prevent manufacturing in a particular country, but if the patents are granted in the importing country, was mentioned before, there may be some situations in which an infringement may be raised, and litigation may arise unless there is a broad interpretation of the parallel importation doctrine that was mentioned before, or another compulsory license is granted.
Thank you, Professor Correa. I'd like to address the next question to you, Nirmalya, which is about clarification about the need of an importing country. In which conditions would it still need to issue a compulsory license? And the issue about potential concerns of double compensation to the right holder in the case that you will need both a compulsory license for an export and then a compulsory license for importing. So how far did the decision address these issues? And if you can clarify, you had mentioned this already, but again, seeking clarification from the question. Thank you.
Thank you, Viviana. So with regard to the importation situation, the question is that if the country where the product is going to be imported does not have patent protection over the same product, then of course the issue of granting a compulsory license does not arise. It could import it anyhow without that. But if the product is under patent protection, then the question will be whether to grant a compulsory, you would have to override that patent through the grant of a compulsory license. And when you grant a compulsory license, it would be subject to the payment of remuneration, because this is not excluded in terms of this decision. In fact, the provision relating to remuneration states that determination of adequate remuneration may take into account humanitarian and not-for-profit purposes. So while doing that, the question is, how do you go about remuneration? You might then consider, so this is up to your discretion. There are certain guiding documents of WHO guidelines, for example, that are referred to in the footnote. But when you are going about determining the humanitarian and not-for-profit purpose of the specific vaccine distribution program in relation to which the remuneration would have to be determined, you might then take into consideration the fact that in the exporting country, a remuneration has already been granted. And you may decide that zero remuneration too could be adequate and justified in this context. But then this is subject to your determination. You will have to go through that determination process. Of course, the other option is that you can use the option of parallel importation using an international regime of exhaustion, wherein you recognize that a product placed in the market under a CL would be also a candidate that you could import through a parallel importation regime. That would not attract the issue of remuneration or grant of a CL.
Thanks, Nirmalya. And I believe your question has also answered a specific one also that we see in our Q&As here by Yao King Q. But if there's any element that was not answered, please, we can come back to that in a moment. I'd just like to continue then so that we can also include in our discussion now the issue about the upcoming or negotiation with regards to the extension of the decision to therapeutics and diagnostics. So for that, let me just do a quick introduction to the issue. Apologies, one moment. I hope you can all see my screen. So the ministerial decision on the TRIPS agreement in paragraph 8 sets out that no later than 6 months from the date of the decision, the members will decide on its extension to cover the production and supply of COVID-19 diagnostics and therapeutics. So this element of negotiation is, first of all, to set out the process to arrive at the decision by the deadline, which would be 17th of December 2022, which should be a decision then adopted by the General Council of the WTO. And at least two questions, specific questions are posed, whether or not to extend the decision to cover therapeutics for COVID-19, and whether or not to extend this decision to cover COVID-19 diagnostics. So just offering a broad element for consideration, first of all, is where are we on the COVID-19 pandemic? So as we know, this is constantly evolving. What we've seen recently is that there is an increase in infections. This is largely due to a rapid spread of new Omicron variants. And these variants, we still don't know, what is their potency, but we clearly see that there is quick spread. Now, what this means also is that we cannot be sure about how long can we have immunity through vaccinations. There is some data pointing that they may be less effective to the new strains than to earlier Omicron strains. At the same time, we see that there's increasing country level guidance pointing to the importance of treatments, in particular for unvaccinated people. Now, clearly that is essential, but the data is also showing us that given this evolution of the new spread of new variants, that even vaccinated and boosted people may also be vulnerable to multiple Omicron infections. So clearly there is a need to focus on access on therapeutics. And for having effective use of therapeutics, we need diagnostics, we need to continue testing. So in terms of why do we need to extend the decision or this analysis to therapeutics, the objective was very clear by the co-sponsors in the original proposal that there is a need to increase the global production capacity and the supply, in particular for low and middle income countries that have seen already in the vaccine space, always coming later than those wealthy countries in supply. So if we have business as usual, we see that we already have limited global supply. This is partly because of few producers, in particular for the new experimental therapeutics. And this is due, of course, to intellectual property protection. But we also see then that there is a concern of pre-purchase agreements taking place, which have been done, which means that the supply is already insured, in particular for a few countries, and starting in particular by the United States, which was the first regulatory authority approving some of the experimental treatments. Now, another issue is clearly about affordability. Now, for treatment supply to be ensured, we need to see that purchasing will be assured by governments. But governments have limited budgets, and in particular, if there is a desire that there will be assurance of procurement from low and middle income countries, then we need to look at the question of affordability of individual prices for therapeutics. And so it's very much to assure that we have adequate procurement for ensuring supply, in addition to dealing with the IP barriers. Then affordability is a key issue. We should take a look at options for reducing prices, and clearly increasing generic supply will help to do that. Now, in the case of therapeutics, we have production capacities in developing countries. So there is that capacity to make use of the decision in an accelerated way. And there's also been important government support for research and development. And therefore, this would support that there should be a more collaborative approach versus business as usual for manufacturers of therapeutics. Now, we also need to accelerate research to develop new therapeutics. For example, within the case of antivirals, we know that resistance will be coming. We don't know when that will happen. And that means that we cannot also rely just on the existing therapeutics we have now, even those that potentially seem to have a good impact. And we also need then to be able to do combinations of existing treatments and see if this can also be applied to different populations. Now, it is of concern, for example, that in the case of Drug for Neglected Disease Initiative, they did request access to doses of Pfizer's Paxlovid to be able to do clinical trials that would be assisting in developing new treatments for COVID-19 in developing country populations in Africa. And this was rejected by Pfizer, preferring to control any clinical trials directly. So this shows why having other options for sourcing for research would be also important. Now, it's a general business strategy to do tiered pricing versus selecting markets that may be able to pay more versus those that may pay less. Now, in the case when we have a pandemic, this is not responding to public health needs. This is a business strategy, and it's not aligned to what we need for scaling up access. So if you look at, for example, what happened with the contract between UNICEF as a partner of Act A with Pfizer for Paxlovid, UNICEF was not able to disclose what would be the pricing offered for those 4 million courses of Paxlovid treatment that would go to low and middle income countries. And what this means then is this lack of pricing transparency when you only have single provider really will not help that cause of ensuring that we have rapid access. We also, of course, note that there is a number of patent filings. We don't have a complete landscape because it's constantly changing. The data from the WIPO report, more recent report, shows that up till 2021, at least compared to vaccines, there's 3 times over the number of patent applications and in many more patent offices, and this keeps on growing. Now, the voluntary license agreements that exist at the moment for therapeutics can only be determined as being restrictive in some aspects. While they are beneficial for the objective of increasing access versus the current situation in developing countries, these have their own restrictions. For example, there is a limited number of generics that may be party of these agreements, and this is in particular the facilitated voluntary license agreements through Medicine Patent Pool, which already is better than the bilateral case-by-case voluntary license engagements that the originators might do. But even on these licenses, there is a limited geographical scope as well. For example, many Latin American countries are not covered, so they would not be able to benefit from prices of generic manufacturers that are admitted through these agreements. And if you compare price comparison, just for Paxlovid in the United States, it's being sold at $350. Under the generic production, at least some of the data would show that it would be about 25 American dollars. And Latin American countries and those other countries that are excluded from such Paxlovid and PP license would not be able to access the lower dose. And as mentioned with the UNICEF, it's not clear yet what is the price at which those will be procured through Act A. So this has significant impact in government budget and availability. Now, relatedly, there has been a request for a compulsory license, which is filed by KEI for Paxlovid in Dominican Republic. So Dominican Republic is one example of a country not included in the MPP voluntary license for Paxlovid. So this shows that the model per se, while being helpful, it does not completely respond to especially the speed of the need that we have to increase genetic production, and therefore the decision really would help with this gap. Now, turning to diagnostics. Now, clearly, diagnostics is very important in making use of the therapeutics. For example, in the case, again, of the antiretroviral combination Paxlovid, it is proven to be at least about, well, the Pfizer data, about 88%. For adults, if it's provided in the first 5 days when the symptoms have started for COVID. And usually then there is associated testing that would need to happen to know if you have the virus, to be able to be prescribed with Paxlovid in those countries that are already authorizing for certain uses. As in the case in the United States, it would have to be done that way to be able to benefit from a free access and for a prescription. So for some concerns of the originators, it would be important to note that in most developing countries, there would not be the possibility to have government prescription or government pricing, government purchase for prescription for such antiviral if it had not been accepted for the indication of COVID-19. So while there might be this argument of, these therapeutics can be used for other purposes and not only for COVID-19, well, clearly this is a regulatory aspect. It's not something that the decision in any case would cover. And there is that pathways to ensure that this would not be deviating. And, very few people would try to, if they cannot get prescriptions and not free access, it would be difficult anyway that they would seek this for other use. Now, with regards to diagnostic testing, developing countries are way behind if you see just what's been accessible. So clearly, access to diagnostics is a priority. We need to continue testing, again, as was mentioned, because we don't know how the continuous evolution of the pandemic will be. And there's a number of patents filed. I mean, many of these patents would be questionable in different jurisdictions because of the nature of the patents. But regardless of that, there is significant number of patents, in particular also related to CRISPR technologies as well, that apply in diagnostic tests. And there are very few examples of voluntary licenses. Those that we do see, for example, of NHS and others that have come through the WHO effort for pooling of patents have come for early technologies for diagnostics. So clearly, with the decision extended to diagnostics, it might help clear up some of this pathways for increasing diagnostic production. And just to mention that in addition to the ministerial decision that we're discussing now with regards to compulsory licensing of COVID-19 vaccines and the negotiation to extend to therapeutics and diagnostics, there was also another ministerial declaration decision that was adopted with regards to future pandemics. And here there is a mandate to look for solutions for future pandemics, including on intellectual property and technology transfer. So there will be a future work program on this. This is also to highlight that this is another perhaps window of potential opportunity, or at least for discussion about those issues that were not well covered or that require further attention and decision that does not fit within the current scope of what is in the decision and the current negotiation. So with that, I will be coming back to look at what we have as questions, and we have 10 minutes left for our webinar. So already apologies if we are not able to cover all the questions that are being posed. I would like to start with those that are specific on the TRIPS decision, and perhaps if we have time, we can put some more contextual ones as well. There is a question with regards to the potential extension for C19 to cover tests and treatments, if it might be agreed or will it be a major fight? Of course, this is to be seen. I'm not sure if also Nirmalya or Professor Correa would like to add anything with regards to what you might foresee might be consensus. Can we reach it in the 6-month period? I would say that might be the question. If either of you would like to address that?
Well, I may, Viviana. Well, I guess it would be a difficult process. We know, for instance, that United States from the very beginning rejected any talks or text-based negotiations beyond the patents, and so there may be a vote against an extension. In any case, the decision was adopted by consensus, And there is one specific paragraph, paragraph 8, that refers to a decision needs to be taken in relation to the extension of the decision in these other two areas of therapeutics and diagnostics. So the decision to be made is about extension, is not actually to renegotiate the terms of this decision. I would tend to think that if there were renegotiation about the conditions of the decision, some developed countries will attempt to introduce more restrictions rather than waive some of them, or in relation, for instance, to notifications or some limitations that may arise out from the footnote. So I think we need to expect quite a difficult discussion for the extension. There will be a lot of opposition, I guess, from developed countries.
Thank you, Professor Correa. And clearly the issue that there is capacity in developing countries will be one of the questions, or why there might be opposition to the extension, because this can really help to expand the supply, which means, competition for those existing players. But it'd be very important to build on all potential arguments for supporting that the decision gets extended and that the discussion especially does not get prolonged beyond the dates that are settled. The TRIPS Council will be meeting to discuss this for the first time tomorrow and Thursday. So also delegations will be considering this under their agenda item 11 of the TRIPS Council. I see there was just one more question, which already has been answered. Thank you very much to Yongin Ku for answering the question posed by Joe Karp-Sawe, which was with regards to the mention I made to summon data of potential $25 doses for Paxlovid. And yes, that comes from an agreement announced by CHI. And again, the UNICEF agreement, we don't really know what is at least I don't have information of what is that pricing arrangement for those 4 million doses that would be supplied UNICEF via Act A. So any other pricing information would be useful. And then again, I mean, we discussed more Paxlovid because it's the one we have more information on, but there's many other potential treatments. So those would be as well important ones to look at in the scope of what the decision seems to access. Okay, so that seems to bring us to the end of our webinar. Thank you all for participating very actively in the chat and those who posed the questions. Oh, my apologies. I see we did not cover another question. It's about the general context of the negotiations in the WHO with regards to a potential international instrument on pandemic preparedness and response. And would there be a possibility to include there a waiver for intellectual property within the scope of this international instrument? So that would be in WTO context. There is in the current outline of the white paper the theme of intellectual property, but without the measures that would be introduced. With regards to what might be achieved there, if Nirmalya or Professor Correa, you'd like to make any comment?
Nirmalya, you are following very closely the process in World Health Organization.
Thank you, Professor Correa, and thank you for that question. So the discussions on the pandemic treaty are still in its infancy, as it were, in the WHO. The INB is currently considering an outline on possible elements of the treaty. The question of whether the IP and waiver of IP rights in the context of a pandemic could be addressed in the treaty needs to be looked at in the light of the fact that we we would essentially, by doing that, would be trying to address an element in the TRIPS agreement and fix something which is essentially about the TRIPS agreement. So at best, what we can get, in my view, in regard to an IP waiver-related aspect in a pandemic treaty discussion, which is outside of the WTO, would be a sort of an exhortation to member states or signatories to the treaty to work towards a solution like that in the context of the WTO. But whether we will actually have that would have to be operationalized at the end of the day in the TRIPS agreement. The solution, the real solution, we will have to find in TRIPS itself. So yeah, those are my initial thoughts on this. We will see how whether member states make proposals which are much more radical and would be accepted or not. But that's my initial thinking on this. The other, I see another question also in the chat about some fact that some have suggested that IP may not be a barrier for diagnostics, and whether diagnostics and therapeutics can be collectively addressed under the decision. And it's interesting to look at, for example, section 92A of the Indian patent law, which is in relation to operationalizing the Article 31 BIS system. But what is interesting is that in section 92A of the Indian patent law, and I'm just opening that provision, there is an explanation at the end of the three clauses in that section, section. And the explanation, it reads that for the purposes of this section, pharmaceutical products means any patented product manufactured through a patented process of the pharmaceutical sector needed to address the public health problems and shall be inclusive of ingredients necessary for their manufacture and diagnostic kits required for their use. So this is not unprecedented that diagnostics in relation to therapeutics have a close intrinsic linkage. This is already, for example, recognized in the Indian patent law, and it's therefore important to keep that real linkage in our perspectives when we discuss this, because without proper access to diagnostics, you may not be able to have proper access to the right therapeutics. Everybody will not know which therapeutics to administer in the first place. So the two would sometimes go together, and therefore it would be a prudent approach to align the two together, in my view. Thank you.
Thank you, Nirmalya. So we have come to the end of this webinar. Perhaps just to summarize a few of the key themes that we heard. One is that the decision that was adopted covers only COVID-19 vaccines, but there are clarifications and one particular waiver. There's more details. We'll have a policy brief on this with more details, but several already of the papers of South Center have been posted here in the chat. So feel free to take a more detailed look at that. This recording will also be available so you can follow with more detail, if you like, on your own time, some of the explanations that were made on the existing decision. Now, the second point was with regards to the need to start implementing the decision. This means countries, now that you have the decision, this will not implement itself. So therefore, national action is necessary. It depends on the national legislation and context, but there's much that can be done. And while it seems that there might be several steps, this is all something that can be done. It just requires, focusing on who will be the institutional party to do so. And South Center can also provide assistance in doing that. So we really encourage now is to think now on implementation of the decision. And now with regards to the negotiation for therapeutics and diagnostics, it's building now the case to say why this is necessary to be extended. And at the same time, recognize that there's many measures within the existing flexibilities of the TRIPS agreement that can already be made to make use of or to overcome those obstacles of intellectual property, whether it be patents or others, with regards to access to therapeutics and diagnostics themselves. Diagnostics, it really depends on what's the scope also of what may be patented in this area. So it'll be important to make a diagnostic domestically of what can be done. And already we would encourage to make use of flexibilities, including compulsory license for therapeutics as you await the decision as appropriate, this decision. So it does not mean that this has to be a one-step process and then decide, but you can already use existing tools as well. So to everyone who has posed the questions, thank you very much. We hope that those have been answered. And there's many other issues and commentaries that have been very valuable that have been posted on the chat. So thank you very much for sharing your thoughts there. And we look forward to a next opportunity to engage with you. Thank you very much, Professor Correa and Nirmalya, for sharing your time and your expertise with us as well. Thank you, everyone. Have a great morning, afternoon, or evening.
Okay.